And in a consequential ruling, the Supreme Court granting former President Trump substantial immunity from criminal prosecution, that effectively reducing the likelihood that Trump's 2020 election trial will happen before this year's November election. Joining us now live is NTD's White House correspondent, live from the White House. Good evening, Iris. So how are both the Trump and Biden campaigns reacting to this?
Good evening to you, Steve. So former President Trump is hailing the latest Supreme Court decision that grants him broad immunity over official acts he conducted while in office. On Truth Social, Trump said the decision is, quote, a much more powerful one than some had expected it to be, while also arguing that the high court, quote, totally dismantled most of the charges against him. But President Biden's campaign, meanwhile, is using this ruling to fundraise, telling their donors and supporters that today's ruling on this case, quote, granted Trump breathtaking immunity from prosecution. It also invited Democratic Congressman Dan Goldman to speak on a press call. Here's what the congressman said. Watch.
There will certainly not be a trial in that case before the election. If Joe Biden is not elected in November, we will not have a democracy.
And specifically in a 6-3 ruling today along ideological lines, the Supreme Court ruled that Trump has immunity over some of his actions, but not all of them. Chief Justice John Roberts wrote in the majority opinion that, quote, the president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but under our current system of separated powers, the president may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive immunity from prosecution for his official acts. Meanwhile, the three liberal justices argued that the decision had created a, quote, dangerous new precedent for American presidents, with Justice Sotomayor writing her dissent, quote, with fear for our democracy. And next up, U.S. District Judge Tanya Chutkan in D.C. will need to decide first whether the alleged conduct against Trump is within the core duties of the president, and second, if that act is considered an official act or an unofficial act. Meanwhile, that process of deciding where the line should be drawn will potentially involve more hearings, more debates, and even potentially witness testimony and even appeals from either side. So that process itself will take a long time. So effectively, today's ruling, no matter how it's going to turn out within lower courts, it means that Special Counsel Jack Smith's prosecution against Trump involving the 2020 election is effectively delayed, and that's a major blow to the special prosecutor, but also a major win for the Trump campaign. Back to you.
NTD's Iris Tao reporting live from the White House. Thank you, Iris. Former presidents have broad immunity from criminal prosecution in official acts. This is what came down in a highly anticipated ruling from the United States Supreme Court earlier today. Here to assess this unprecedented ruling is Mark Meckler, president and co-founder of the Convention of States Action, and Claire Wofford, associate professor and director of the Pre-Law Advising Program at the College of Charleston. Mark Meckler, Claire Wofford, thank you so much for joining.
Good to be with you.
Happy to be here.
Great to have you both. Claire, I'm going to start with you. Earlier today, obviously, the Supreme Court in a 6-3 decision sending it back to the lower court for further proceedings in the case brought by Special Prosecutor Jack Smith. Talk about the historical precedent this ruling sets and how it distinguished between official and unofficial acts of a president in conclusive and preclusive authority.
So that's a very good question. Today's ruling is a major decision of constitutional law. It will be read for decades to come. And in it, the court did exactly what it told us it was going to do. It decided whether and to what extent a president is immune from criminal prosecution. In the substance of the court's opinion, they really gave a major victory to Donald Trump. They didn't give him 100% of what he asked for. In other words, there is, at least in theory, a world in which the trial against him will proceed, but they made the grounds on which that trial can proceed to be narrow, I think even more narrow than they claim in their opinion. You're correct to hone in on an important distinction they made, or that they declared, was that a president, Donald Trump or whomever, is immune for official acts he took while president, but is not immune for unofficial acts. And they've sent it back to the district court to determine which of the actions alleged in the indictment is official or which ones are unofficial. Now, where that line is drawn is left a little bit, to understate it, unclear. The court gave hints in its opinion that I think are really going to make it difficult for Judge Chutkan to find a lot of his actions to be unofficial. The court, in fact, used language from another opinion that said, as long as you could plausibly consider an action of the president to be official, it was therefore official. So even though they didn't draw a clear distinction, even in this case, between what's official and what's not official, they made it very, very difficult for most of what Donald Trump is alleged to have done here to be declared unofficial and therefore subject to prosecution.
Mark, if you could weigh in on your take on this ruling, and also how important was the ruling, not just for former President Trump, but for any future president to know that they have some level of immunity?
I think this immunity question is very important. A president is operating with extreme authority. Remember, the president himself is the representative of an entire branch of the federal government. And if a president can't operate at the edge of that authority, believing that he's not going to be prosecuted for things that are done within his official capacity, it makes it very difficult to even have an effective presidency. So I think they did push that out to the edges. They used the word perimeter, acting to the perimeter of his actual authority. That's where he's protected. So I think this is a major ruling which frees the president up to do the things that he's supposed to be able to do. Now, I think the left is wildly overreacting. They're making all kinds of, I would say, unsubstantiated, ridiculous claims that the president could go out and assassinate his opponents and things like that. The court said nothing of the kind. They're getting some of this language from the dissents. I think the dissents were fairly outrageous in this case. I think the court was reasoned and limited in its ruling. And I think this is going to be, as the professor stated, something that people are going to be reading for a long time to come.
And Claire, if you could just walk us through how you see this playing out in the lower court.
So as I indicated earlier, the case has been remanded back to the district court for, first of all, a determination of which acts in the indictment Trump can be prosecuted for. And again, that's up to Judge Chutkan making a determination whether or not they are official. And I presume she will take briefing from the parties and there will be argument about that. And that her decision in that case is potentially subject to an interlocutory appeal. So we're looking at a significant amount of time before any trial of Donald Trump moved forward. I will make just two other quick points about what may or may not happen in the lower court. The court actually the majority walked through many of the allegations in the indictment and declared one of the set of events, Trump's discussions with the Attorney General and the Justice Department, to be part of what they called his core functions and simply not subject to prosecution in any way. So the allegations in the indictment about Trump's conversations with the Attorney General and the Justice Department, those have to be dropped out. So those are no longer going to be part of any trial. The court also talked about Donald Trump's discussions with his vice president about what the vice president could or could not do in terms of disrupting the certification. And the court was sort of a little bit wishy-washy about that, said we think that that's probably not subject to prosecution, but the government can overcome that presumptive immunity by making a showing about intrusion on the executive branch. And then when it comes to other allegations in the indictment, the public statements made by Trump, his contact with state officials, it sent it back down to Judge Chutkan for her, again, to determine whether or not those fall within the outer perimeter of the official duties. And the court did make a note, which became clear in oral argument, that some of the actions that Donald Trump is alleged to have done, reaching out to private attorneys, et cetera, both sides agree are private actions. So trial can proceed on those set of actions alone without a determination about immunity. So you're looking at a long complex process in the lower court before we see any trial begin, unless Jack Smith makes the decision that he's only going to prosecute Donald Trump for what is considered private actions. That significantly weakens his case against the former president.
Now, Mark, what precedents or previous Supreme Court rulings did the justices rely on, if any, in reaching this decision? And what course of action do you see Judge Chutkan taking now that things seem to be being kicked back into her hand?
Yeah, two layers there, and relying on precedent, honestly, not so much. And I'll defer to Claire, as I know she teaches this stuff, but mostly they were treading new ground. And they talked about that they weighed in on this case because of its precedential importance, that they were in territory where we haven't seen presidents prosecuted before. And they were very careful to make a distinction between weighing in on the current situation and its political ramifications versus what this meant for the future of the presidency in general. That was actually my favorite part of the opinion, where they talked about we're trying to do something that's going to allow our republic to function in the future. On a purely political basis, I think this is a huge win for Trump. Claire mentioned this, the time perspective. Clearly, it's going to be very difficult to get any of this stuff to trial. I would say 2025 and maybe even into 2026. These are incredibly complex factual situations, a myriad of angles on each set of facts. So if he's going to broadly prosecute, you're looking at a very long prosecution.
Mark Meckler, Claire Wofford, thank you so much.
Thank you.
And Republican lawmakers calling for an end to the prosecution of former President Trump after the Supreme Court rules in favor for presidential immunity for official acts. This while Democrats warn the ruling could be a slippery slope. Our Washington correspondent Luis Martinez has more.
Minutes after the Supreme Court announced its decision on presidential immunity, Senate Majority Leader Chuck Schumer took to social media to criticize the ruling. The Democratic senator rebutted the court, saying treason or incitement of an insurrection should not be considered a core constitutional power afforded to a president. Schumer also added that the decision undermines the court's credibility, while House Minority Leader Hakeem Jeffries condemned the ruling and argued that the framers of the Constitution did not intend for our nation to be ruled by a king or monarch who could act with absolute impunity. Democratic Congresswoman Alexandra Ocasio-Cortez posted on social media that she intends to file articles of impeachment against Supreme Court justices, while Republicans celebrated the ruling. Speaker of the House Mike Johnson posted on social media that the decision was a victory for former President Donald Trump and for all future presidents, and that the decision was based on the obviously unique power and position of the presidency and comports with the Constitution and common sense. Chairman of the House Judiciary Committee, Congressman Jim Jordan, also highlighted that hyper-partisan prosecutors like Jack Smith cannot weaponize the rule of law to go after the administration's chief political rival. House Republicans expect the decision to put pressure on Special Counsel Jack Smith and on the Department of Justice to put an end to investigations against former President Donald Trump, while House Democrats have signaled that they're willing to use the powers of the legislative branch to redress their grievances surrounding the Supreme Court. Reporting from Washington, D.C., Luis Eduardo Martinez, NTD News.
Thank you for watching the Capitol Report. If you want to see our full broadcast, check us out at epochtv.com.